Thanks, Eliana, for the question. I mean, that allows me to try to explain how a young lawyer in Italy in the late 90s decided to step into this new realm of mediation and alternative dispute resolution tools in general. And that actually was a sort of a jump into the darkness, because there were very few people at that time in my country who were even aware of this tool called mediation, or conciliation, as is alternatively mentioned. And so probably when you say how, the short answer would be by attending one of the then a few mediation training courses that were provided by the local chambers of commerce. The good point, since I'm talking to you, Liliana, is that my trainer was a former Argentinian lawyer. And Ana Oskeda has been a lawyer there, and she trained at Harvard and provided the Harvard way of negotiating and mediating disputes, and was smart enough to become the one of the first trainers in mediation in my country at that time. And so to say why mediation? Well, at that time, as a young lawyer, I was always eager to look for opportunities. And I envisaged that mediation could have a way in standing beside the other more traditional ways of handling disputes, that is litigation and arbitration. And the time told me that I was right, because actually after 25 years, I'm still on the forefront of the mediation movement in my country, and I can be one of the few people in my country that actually were able to handle thousands of mediation cases. What I really like about it is the fact that actually mediation allows parties to sit down and talk. Sometimes this is something that is not allowed to parties. It's definitely not when they ended up in court, because judges are not familiar with handling this kind of stuff with the parties directly. They just have the lawyers, they talk legalese, they both talk the same language, and parties possibly can stay away from the law courts, okay? Because the judges don't know how to handle them and don't want to handle them. So that's the point. But in other ways, mediation is different. Mediation is a way to allow parties to talk together, and to do this with the assistance of a third party, a learned third party neutral that help them to find a suitable way to solve their issue. That is very attractive to me, both as a lawyer and as a mediator. And again, I would say that after so many years doing this kind of job, I was right in thinking that at that time, and I'm very proud of being here now. Describing mediation in one word, that word for me should be options, okay? And I'm using that in the plural way with purpose, okay? Because it's not just an option, an alternative to other. No. Mediation means dealing with options, okay? So there are many ways to solve your issues, many ways to even deal with an issue. The good point of mediation is there to remember you that there are options, okay? That's very nice. I mean, so wow, way back to 1999, I guess. It was, I can't remember if it was actually 1999 or the very early 2000. I was assigned with my first ever mediation, being appointed by the local chamber of commerce here in Florence, where I live. And I can remember it was a fairly simple kind of dispute. It was a contractual dispute. We were capable to handle that litigation entirely by way of mediation. The parties were fairly receptive one with the other. There was just a need of deciding how much to pay for the work done. That was, of course, contested. So we have to think about a figure that was probably somewhere in between the original request and the actual offer or counteroffer made by the other party. And eventually we were close to reach a deal, to make a deal, reach an agreement on a certain amount of money, up until one of the parties' lawyer, a young lady, posed the most dreadful question that a lawyer can pose at the mediation table. That is, okay, that's very nice, ladies and gentlemen. So what about my legal fees? And of course, her legal fees were way above the entire value in dispute. And of course, the party that was prepared to accept a reduced amount as a result of the mediation, she had to give up and say, okay, if I have to pay to receive a money and then just divert it to my lawyer and even put something on top of that to pay her, that would be okay. No, I prefer to go in court and make my day in court. Okay, so actually it was a no deal, my first proceeding, but so the kind of feelings that I had, well, I still have the thrill, of course, of being solo for my first time, and also the realizing the fact that I was good to some extent, probably had to be to refine my expertise, of course, but also the detecting the difficulty of handling a lawyer at the mediation table, because of course the real truth was that we have to inform parties at the very beginning that their lawyer's assistance is something to account, because there may be cases where the lawyer is just a friend of the party that can make very, very favorable and reasonable request of fees at the end of the mediation because of the mediation, other than just going to litigation. So there are opportunities even for lawyers to be fair and to treat their parties with fairness with what concerns their fees. Nonetheless, it's something that can be an issue in mediation. The only way to deal with it, in my opinion, is to make the parties aware from the very outset, the very beginning, that could come out, so that you're not caught as a turkey in the dark and not being able to handle that. Okay, so the final point is that I was right to decide after the mediation at that time not to give up, because sometimes when you just say receive a no, it's just for if you're dating your fiancé, your future fiancé, if you just receive, it's quite common to get a no as a first answer. But you can't give up, otherwise you're lost, okay? So you have to insist, and I was right, because after more than 5,000 cases, I can tell you I was right. In my opinion, in answer to that would bring me to talk a little more about the activity or the fact of being a lawyer and a mediator in my country. What I can tell you is that the biggest challenge still is the difficulty to be recognized as a profession. Okay, being a mediator is something that actually cannot make your living. Okay, you can't live out of mediation alone. And that's a pity, because in other countries, United States, sometimes even in the UK, other places in Southeast Asia, etc., I know people, colleagues of mine, who actually are sole mediators, in the sense that they just provide mediation services and that's it. I know some very few Italian lawyers that decided to go out of their bar and get involved only with mediation. They tried to, but of course they couldn't leave with mediation only because the profession is not settled, because it's still quite difficult to get a fairly large and ongoing stream of proceedings that would allow you to invest on your profession, your business, and to make more money. So the actual way to handle that in my case was to just keep it besides my own legal profession as the owner of a law firm in my home city. Okay, so the idea, what I noticed is instead that actually I was able to apply a sort of variable geometry kind of business. What I mean by that is that I started doing, let's say, 90% of my work as a lawyer, 10% as a mediator. And then after the years, this 10% being a mediator climbed up to become even 70%. Public entities here in my country, and those, especially those who were provided a steady stream of proceedings in mediation, I was actually spending much of my time as a mediator rather than as a lawyer or litigator. Okay. Then the typical turmoils that occur at the legal stage when you are talking with Italy forced me to reduce dramatically this amount from 70, and now it's about 30%. What I noticed is that in parallel with my profession as a mediator, I was also able to develop a profession as a mediation trainer. So that training part of my business is now covering another 30% of my time. So now it's pretty much balanced. 1/3 of litigation or legal counseling, 1/3 of mediation, 1/3 of training in mediation. That's a way to cope with this issue. Main value for me was being acknowledged and recognized as a professional mediator who not only has its own experience at the national level, but feel himself capable and able to also provide his services worldwide on the international stage. I approached IMI probably soon after the Institute was created. And I was approached actually by Irena Vanenkova, who was at that time very active worldwide in letting people being aware of the activities carried out by the Institute. I felt more keen with the goals of the Institute, which is why I wanted to become an IMI patron first, and then remain close to the IMI activities. In my opinion, as you mentioned earlier, there is a need, even at international level, to know what mediation is all about, with all the pros and cons, all the limits, but the opportunities that are offered from mediation as a process. And also there is a need to learn about the capabilities of the single mediator. Unless you have a sort of rule of thumb, okay, ways to detect and recognize, or at least in an interview, focus on those elements when you are selecting a mediator, or when you, at the very end of a proceeding, had to provide feedback to your client or to other constituents about the mediator's performance, you need some point of reference. And what, in my opinion, IMI does provide to the community, not only the business community, but in general, is those guidelines, those, the process of think tanks, people that have experience in mediation, people that have experience in the business sector, gather together, talk about what is really needed, and end up and come up with workable, I wouldn't use the term rules, let's say guidelines, okay, that can guide not only people in selecting mediator, but the same mediators to follow a professional path towards their activity, their job, okay? And even recently, IMI also embarked in providing guidelines for mediation organizations and training organizations, which is of paramount importance because you have to go all the way up and probably approach the universities or even the high schools and go people what mediation is all about and how can be conducted in a professional way. And I can be a witness for that. I mean, in this week, we are experiencing the ICC celebrating their 100th anniversary. Okay, and ICC is currently conducting a negotiation competition in Paris. And I know the IMI has to have meetings over there. What is interesting is, again, I'm talking this as a direct witness on this. ICC does provide value to IMI, yes, I know, to the extent that in selecting prospective mediators to offer to the parties in dispute and bring that dispute in mediation via the ICC rules, they thus provide importance to the fact that the prospective mediator is an IMI certified. And I can tell you I was appointed for a couple of mediation proceedings carried out under the ICC rules, and I'm pretty sure that besides my own experience, what really appreciated them was the fact that I was IMI certified. And I cannot speak for the committee, for the subcommittee. I can only speak for myself as a member of the subcommittee. So for myself, the role played by the IMI MCIArb appraisal subcommittee is let's say, a sort of watchdog of quality assurance, okay? Once IMI issued, and we were there, myself and others, were able to set up the rules that has to be used by organizations, training organizations who would like to train future mediators from the very outset, from the very beginning. And it's not our own scope as a committee in being appraisers to verify that all applications from potential IMI CMTP training organizations would comply with the rules that IMI devised. Okay, and what I can tell you is that, in my opinion, this appraisal activity is of paramount importance, because after probably, I can't remember, probably 30 or something appraisal that I made in all these years, there is a lot of issues that probably local organizations don't even understand or are not aware unless there is this exchange of comments that come from us as appraisers to them, and then this dialogue that is conducted thanks to you and the other people, the IMI, that probably make really them aware and capable to understand what are the aims of those guidelines, of those rules, so that they become better trainers at the end of the appraisal time, okay? So this is the role, I guess. It's a role of enhancing people about their being trainers, okay? Because it's we want that they be aware of the importance of their activity as trainers, because they are training future mediators, and we want this quality passes through them from the very outset, very beginning. I would say only 3 words that are: don't give up. Okay, so the lawyer, I mean, especially the young mediators tend to, to approach this new world for them with a lot of enthusiasm and a lot of expectations. Unfortunately, this is not the case, because mediators, as I previously told, is not yet a recognized profession, and there are so many people that struggle to have a fairly large amount of cases that would allow them to make a living out of them. But here comes the good news. Things are changing rapidly. There are trends that definitely throw signs in the direction that goes in favor of mediation. What I'm saying with this is that, for instance, at the lawmaking level, there are ever more initiatives that include mediation, that sort of institutionalize mediation as a dispute resolution method, okay, alongside arbitration and litigation. There are, for instance, in Italy, very recently, as perhaps people that will listen to me are aware of, Italy, like all the other EU member states, have to cope with the next generation EU fund program. What I mean by that is that the European Union, in order to help member states to come out of the pandemic era of the COVID-19, issued, they provided them with the opportunity to be funded in the hundreds of billions of euros, provided that they will come up with reforms in their, the 360 degrees kind of areas. So for Italy, that would account for a little less than 200 billion euros, okay, in funds from the European Union. So Italy has to cope with the difficulties that is provided in her own attractiveness for business and for investments, due to the extremely low management and low outcome in handling the judiciary. Okay, so one way that was envisaged was to refurbish and increase these ADR tools, and especially mediation, to the extent that now mediation is considered mandatory. And of course, we are talking with an Argentinian, and you know that you were really at the very forefront, at the very beginning, employing mandatory mediation. Okay, now after so many years, of course, we refined several times this concept of mandatory mediation as a condition precedent to access the courts. And probably we reached a sort of equilibrium in which parties are invited, strongly invited, to sit down at the mediation table, to listen what the mediator has to tell them, and go out only if really they couldn't find a way at that time to proceed further on into the mediation and eventually come up with a settlement. And mediation, as a mandatory part, is enlarging its scope to cover areas of disputes that previously were not included. And even the public administration now is strongly encouraged to sit down at a mediation table and listen to what the mediator has to say. There are signs that at the end of the line for the mediators, for the young mediators, should be good signs in fact to receive more and more cases because of this new approach and more favorable approach to mediation by the legislator. I'm pretty sure that in other countries is not for the same reason, of course, but it's happening just the same. I can see this at the European level, where other countries followed the Italian way of mediation. I know Greece, Turkey have experienced recently adopted mandatory mediation. Spain is considering to do the same very soon. Other countries are reconsidering, even the United Kingdom. Okay, the old Albion at some point realized that possibly mandatory mediation is not an oxymoron, but can be employed in a fashionable way to, at least in their case, reduce the workload of the judiciary for what pertains to the so-called low-value kind of disputes. So it's don't give up. Again, there must be a way for them also to make a living. Okay.